3024 is motions to correct pleadings. Motions to correct pleadings. The time frames in this article is 2010-10. A notice of motions to correct pleadings are vague or ambiguous or scandalous or prejudicial shall be served within 20 days after service of the challenged pleading. If the motion is denied, the responsive pleading, the answer, shall be served within 10 days after service of notice of entry of the order. If the motion is granted, then the amended pleading complying with the order shall be served within 10 days. So once again, 3024, you have to make a motion. If somebody serves you with a pleading that you think is vague or ambiguous or scandalous or prejudicial, you can serve a motion, and that has to be made within 20 days after service of that challenged pleading, the same time frame that you would have to answer. You would have to serve that motion, and once that motion gets decided, whether if it's denied, then you have to serve your answer within 10 days. If it's denied, then you have to serve your answer within 10 days. And if it's granted, then the person has to serve the amended pleading on you within 10 days. In 10 days. Saving me?
No.
Okay.
This is different in special proceedings. Article 405 says to make a motion to cure a defect or omission in the record or strike scandalous or prejudicial matter unnecessarily inserted in a pleading. The party must move within the time to answer. If it's granted, he has to serve his responsive pleading within 5 days of the corrected pleading. Because if the motion is denied, then he has to serve his responsive pleading only within 2 days. Then they can re-notice the matter to be heard within 2 days. So the rules are different here. It's a 5, 2, and 2. Please don't mix this up with objections in point of law, because those time rules are 5, 2, and 7. 5, 2, and 7. 5, 2, 7 in a special proceeding. Objections in point of law. Okay. So the only difference here is that the one I talked about was for a special proceeding, and the time rules are 5, 2, and 2.
And the one I spoke about is for any other action other than a special proceeding, and those time rules are 2010-10.
Got it? The special proceeding one could also be to cure a defect or omission in the record. I'm not sure if that's true in the other one, but either way, they're both motion to correct pleadings, both about vague or scandalous matter in a pleading, and the time rules are the only difference between the special proceeding and the action.
2101, a party on whom a paper is served, just a paper, not a pleading, shall be deemed to have waived the objection to any defect in form unless within 15 days after receipt thereof the party on whom the paper is served returns the paper to the party, serving it with a statement of particular objections. So, when my doctor serves me with some papers, he serves them to me, and I don't like something, I'm objecting to the defect in form. So I have to, within 15 days, send those papers back to him with a statement of particular objections.
Okay, so the other objection about form, 3115, and this is talking about an objection to a defect in the form of a disclosure notice. So objections to qualification of person taking deposition or the form of written questions are waived unless written objection is served in writing upon the party propounding the questions within the time allowed for serving succeeding questions or within 3 days after service. So, yeah, so basically disclosure one is 3 days for objection.
Okay.
All right, so to put a bow on this, disclosure, the objection in the form thing is 3 days, generally, okay? 3 days after service. For a special proceeding, the objection rules are 5, 2, and 2. For an action, it's... Are you going to say it?
Oh,
action, yeah. The rules for the action.
The 2010-10 rule?
Yeah, there you go.
Okay.
All right, so that was 2010-10. The papers, it's 15 days. So
not going to be able to call. I forgot the fucking pizzeria's name. I can't even call them. I just remembered. All right, here goes. Would you guys like anything out there in video world? I get a regular hello? To even talk, I get my pizza. Everybody knows over there knows what I want. 3043. With some exceptions, a party may serve a supplemental bill of particulars at any time without leave of court, but not less than 30 days before trial. And a supplemental bill of particulars is what, Mary?
A supplemental bill of particulars. A bill of particulars that is served not less than 30 days prior to trial, alleging continuing special damages and special disabilities. With respect to claims of continuing special damages and special disabilities.
Within 30 days of service of a demand for a bill of particulars. That means if my doctor botched up my boobs, he can demand from me a list of the particulars of the things that I feel why I'm entitled to money and compensation for these things that I got to carry around for the rest of my life. So he can serve me with a demand for this bill of particulars, and the party on whom the demand is made, that's me, I shall serve my bill of particulars complying with each item in the demand, except any item to which I object, in which event the reasons why I object shall be stated with reasonably particularity. Okay, so now the demand for the bill of particulars, bad doctor served me with this demand because he wants to settle this case with me. So he wants a list of particulars of what's wrong with me and how much money and whatever. Within 30 days of the service of his demands, I have to serve him with the bill of particulars within 30 days. He demands it from me.
At any time.
At any time. And I got to serve him with that list within 30 days. Now, with some exceptions, I can serve a supplemental bill of particulars, another bill of particulars. And that's also at any time and without leave of a court, but I have to do it not less than 30 days before trial. Not less than 30 days before trial. Oh shit, my pizza. I want pizza.
Any party served with a note of issue not containing a jury demand may make a jury demand within 15 days after the service. That was right?
Of the note of issue.
Of the note of issue.
Note of issue not containing a jury demand may make a jury demand by serving upon all parties and filing a jury demand within 15 days after service of the note of issue.